first of all, like, losing trials just suck. They're just the worst thing ever, right? And I feel like we don't really, do you want me to stand up? I'm sorry.
No, you're good.
That's okay.
I'm not in there,
No, I can put you in there if you want me to.
No, I don't want to be in there either.
so if I'm here, move back.
So I guess I just thought it would be kind of interesting to just talk about like why we are so bad at losing. Because I feel like it's like, I don't know about you guys, but I guess I should just start by saying this. I work in an office where we actually win a lot. We win almost all the time. I'm not saying almost all the time, but we win more often than we lose, which is sort of unusual, I think, in, if you did like percentages, probably most public defenders and defense attorneys in general, they lose more cases than they win. And you can apply any of this to sentencing as it relates to pleas also. I don't know about you guys, but sometimes, often enough, I get sent out to trial and, my client will take a plea kind of at the last minute and, you've done all this work and you've invested yourself in this case and then the case gets pled out and, that feels sort of like a weird failure too. Even if it seems like the right thing for your client, it still sort of doesn't feel great. But in my office, there has sort of developed this kind of weird fear of going to trial, a little bit of a fear of going to trial because you're afraid to fail, because there's an enormous expectation to win. So after, or if you lose a trial, so there's just like all these emotions that go on. And so I just thought maybe we should just talk a little bit about, that, like why it sucks to lose. I don't know. I mean, I tried to this is it. How do we fix that? So, I don't know, I feel like, when we lose, it's really hard to kind of get out of that place. It's really hard. And I don't know, I think the worst thing for me is like I relive the trial, like over and over and over in my head. And it's like I can't really get past it. Sometimes it takes like a really long time. I don't know, what do you guys, like what are your experiences with that?
I think the expectation to win all the time is definitely not in my office at all. But
Yeah, no, I know that's really unusual, but
yeah.
But
still, it's like you put so much into it, and like you do have especially I think it's even worse when all the evidence comes in exactly as you planned it and exactly like to your optimal.
Mm-hmm.
So like
you
when you go into exactly when you go into deliberations or anything, you feel like we did everything. It's all there. It's laid out exactly. There was no like, oh my God, something really awful happened, and then you still get a bad verdict, and you're like, what else could you have done? So yeah.
I mean, I try the trick with myself, which is like, do I feel like I did everything that I could do?
Yeah.
And I say, well, if I feel like I've done everything that I could do,
I should feel
I
better.
should feel okay, and it still doesn't really feel good, right?
You still realize that like a year later, you're like, I could have done this.
Exactly. Like a year later, I have a case that I lost that I still can't get over. I just can't. So I don't know. What about you guys?
I don't know. I get all funked up when I lose cases because I'm one of those people that I run around trying so hard to get everything done right, and it has to be perfect, and this has to be this way and that way, and then you lose, but you don't see why you lost. You know what I mean? Like, there's just no explanation, and then you go home and you start thinking of, oh shit, I didn't do this, I didn't do that, I didn't do that, and you just pretty much psych yourself out, like, shit,
Yeah.
you know, am I gonna get grieved or whatever the situation is, because you're psyching yourself up, and then that's when I have to go sit with, like, my mentors and, you know, certain
That's good.
people, and then they'll talk me down, you know, like, get over it, you know,
Right.
that kind of thing. But I have to talk to somebody,
It's good advice.
yeah,
Um,
outside of a shrink.
Shrink is good too. Although they don't really get it, but it's okay. Yeah, and then I think, so as we sort of move from like the like grieving, blaming phase
Yeah.
and into kind of like dealing with the sentencing, I mean, I don't know about you guys, but sometimes I've been sort of paralyzed and I can't even get myself to deal with it. Like, it's like, I don't want the thing to happen, and so therefore you sort of like put it off, or you don't do the stuff that you need to do. And you know, I find it sometimes like, I'll think about my client and say, well, I don't have anything good to say about him. The trial was a nightmare. The judge sees my client the way that he was seen in the case, or even if I still see the case the way I needed to see it, the judge is stuck with the conviction, right, as the truth of the matter. The only thing you have are like all the arguments about why he shouldn't have been convicted, but he was. So now what the fuck do I say? And it can be really debilitating. I did actually go into a sentencing once after that. This is a long time ago. I didn't do a written sentencing report. I really didn't prepare myself for the sentencing. My client was already doing like 8 years in the feds, and it was a murder case, and he got convicted of the gun, not the murder. And we were in front of actually a really good judge, and I didn't think that the judge was going to punish
Like
him.
slam them.
I didn't think he was going to punish him for the murder. You know how like when judges do that, I didn't think he would do that. It was actually a false confession case, which is, you know, I thought the trial was, you know, went in really well, and I think the jury sort of misunderstood the instruction on the gun, so I thought we had sort of an interesting appellate issue. And he gave him 12 consecutive. And he was like a kid, and I still like in touch with him, and he sends me pictures of like what he looks like now, and I like can't even believe that that's like the kid that I knew, you know. And I don't think it would have mattered if I had done a better job of the sentencing report, but I didn't deal, because I was so upset that he had gotten convicted of a gun. I felt responsible, like we hadn't really dealt with issues about the gun properly, the notes that came from the jury, so I sort of like blame myself for that. So I think that's kind of like a lot, like those are all the things I think that happened, and so I just didn't like force myself to go ahead with like really dealing with the issues for sentencing. So I think that's like a lot of what goes on for people when they're approaching sentencing. I think we also don't really train and talk about these things ever. You know, there's like all these things that, you know, we train on like skills, and we talk about how to try a case, but like these things are just things we don't really talk about enough, I think. So I thought that one of the reasons it would be sort of an interesting thing to talk about. And then I think, you know, we're sort of defensive going into sentencing, right? Like like I said, I think we're like, oh, well, we lost, and like, what is there really to say? And so it's like you're in this mode of like arguing back against the prosecution as opposed to being proactively arguing for your client in a affirmative way. So I think that like we go in with probably the wrong head on about it. And you know, I think it's really like everything that we do. I think if you think about developing theory of a case and thematically presenting your case, those are the ways in which we should be approaching bail. You know, when you get up to do a bail application for your client, like I hear lawyers stand there and do the same rote bail application day in and day out in the courtroom. And it's like, think about what are the strengths, what's your primacy? Is there a theme that you can present for your bail application? Like you can, in a mini version of all the things that we've taught, do bail applications that way. And in my office, we really train on that. Yeah.
Can you give me an example, like, just a...
For a bail like, let's say, I mean, I guess it's like, it's sort of like a case, like you have to figure out like what pops for you, right, about a case. But let's say, like, what happens in my jurisdiction, I don't know how it works for you for bail, but basically the bailout that I hear day in, day out is, you know, Your Honor, my client is 19 years old, he has strong ties with the community, his family is here in court. He has no prior warrant history, he's not a flight risk, he'll come back to court, I'm asking you to release my client. Like, have you heard that a million
Yeah.
fucking times in your
Yeah.
life, right?
Yeah.
So instead of that, you can say something like,
Either use one you've used or.
yeah, I'm just
or
trying to
the
think of
cases.
something, like, I mean, I've done so, you know, it's just about being creative and saying something like, I mean, I've done this, which I think you have to have a little bit of balls to do this, but I have said, you know, Judge, I have met thousands and thousands of clients in my life. And I sat in the cell and I talked to my client, and he is a respectful and forthcoming young man. When he said to the police that he blah, 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 because it just said the statement, and he was sorry, he meant it. This is not a kid that isn't going to school, that isn't respectful of people. I can tell you, like, it's like using your own credibility, which you can do that if you're in front of a judge that knows you and really respects you. You can talk about, I mean, I try to often use flight risk, right, lack of flight risk, but in an interesting way, which is to say, like, how do you take that fact, right? To the judges, that's supposed to be the most, that's really what bail is supposed to be about. And so when you have a case where you think the judge is gonna knee-jerk, hold your client because of some other reason, right? Like, the nature of the charges is just icky, like a stalking case, or something that's like a misdemeanor maybe in your jurisdiction, but it just feels bad, and you think the judge is just gonna set bail as sort of a punitive thing. You know, you can do like storytelling, right? Yesterday morning, Your Honor, my client got up and he went to work. He worked all day, and then he came home to his family and took care of his kids, and he put his children to bed. And he did that the day before, and the day before that. Because that is who my client is. He is a responsible person who lives up to the expectations of everyone around him. And he'll do that if you release him too. Right? There are so many different ways to talk about flight, about being a responsible, you know, to what an order is. You could do it like with orders of protection, if that's what the judge is worried about. You know, you can sort of focus your application on that. It's sort of like, you know, like why storming, you know, we talked about the idea of like going to where your fact finder is, right? The jury is worried about this thing, this is the big question they want answered. Say to yourself, if I was a judge, why would I want to fucking hold this person, right? And if you're, what you're saying to yourself is like, you know, let's say if your client's like, it's a first offense, but it's a sex offense. And you know they want to hold your client, but really there's no real reason for them to hold your client. The first words out of my mouth is, I know that your reaction to looking at this complaint is that you want to hold my client. Because just because of the nature of the charges, that's sort of our reaction in the system to this. But really there's no reason for this person not to come back to court. Let me tell you why. So it's like primacy, right? Like you put out there your theme, you say it first, right? And that's a lot about like being creative and sort of pushing thematic presentation. And that's kind of like the idea behind this. It's like, how do you do that? Yeah. We could just do a whole talk about bail.
I was gonna just say, how do you do that when you have a client that has nothing good about him or her?
Okay, so that's a great question. I don't actually believe there is such a thing. So I don't, like, every single person, every single client that I have met in my life has something good about them. Now, sometimes it's really hard to see that when you first meet them. So I'm agreeing with you maybe on bail, it's harder, right? You've only been with your client in, I don't know.
2 minutes.
Well, okay, well, don't make it 2 minutes, make it more than 2 minutes.
No, because like sometimes, well, in Hartford, when I'm a special, they've already been arraigned, so the public defender's office, like,
Did the original
Yeah.
yeah.
they would have already done the first bail
Yeah.
argument.
Okay.
So now I'm doing a bond redetermination argument.
How much time do you have to meet with your client to do that before you do that?
Usually, by the time that I get the assignment from the public defender's office, the next court date is maybe a week or two.
And when did you, but how much time?
And so I have, if you count the work days, the weekdays and not the weekend, I could literally go spend several hours at the lockup to talk to them
Okay.
before I go to court, so it's not that bad.
Okay.
But when you do get to talk to them,
Mhm.
it's like, oh, you're my motherfucking lawyer, right? So you're gonna motherfucking come and see me, right?
Mhm.
And my bitch ass mother didn't do this, and it's abuse all the way around,
Okay.
and they don't come down from that for like
Right.
2 months.
Okay, so, I mean, look, if that's the reality and that's your client and
Yeah.
that person's not gonna come to you for 2 months, then I don't have, I don't have a magic bullet for that. I mean, I think that, I don't have a lot of clients like that. Now, I don't know if that's because at this point, after doing this for 20 years, I just have a different approach so that when I walk in the door, there is, I'm building like client connection from the beginning,
Yeah.
but.
Sometimes they're like that because,
You're gonna do it really well.
Okay, we're talking about bail, so we're
Oh,
gonna talk about
okay.
sentences.
see, sometimes
Do the whole city on bail.
Sometimes they're like that because they thought they had one lawyer when they first went for arraignment.
Okay,
And
I
then they
can see
feel like
that.
they're being pawned off
Okay,
to me
so then
or
you
someone
need,
else.
then you need a shtick for that. You need a spiel for that. You need like, hey, I am so lucky, like you gotta make it positive, right? Like I was given the opportunity to take this case over from that other lawyer, and I'm really glad that I got that opportunity, because now I can sort of work through some of the things that weren't done and get this case into a better place. Like I think you have to go in there with a sense of kind of like that your client feels that way, right? Which sucks. Try to imagine what that feels like. You can't hire a lawyer that you want. Some person shows up and then they dump you the minute after they get you as a client. And they probably, I don't know, but maybe they don't even give a shit about doing a good bail application because they know you're giving the case away anyway.
Sometimes I think they just want to be in jail. Like, I'm talking about that client with that attitude that
Well,
has only spent like 2 weeks out of jail each time he gets out because he goes right back.
then maybe that's, so wait, instead of being like annoyed, which is what I sense from you about that, right?
Yeah.
That's really sad, isn't it?
Yeah.
It is. Like, if this person has spent no more than 2 weeks of their life out at a time. I've had clients like that, trust me. There is something going on that is making them want to be in jail. So what is that? He's not connected in any way to any other human beings. He's incredibly poor and doesn't have the ability to actually find a way, a place for himself in the universe. That's just sad.
I actually had a whole sentencing memo where I made a chart of the time my friend had been in custody and not, and it was sort of a situation like that where it was like sort of 2 weeks, 3 weeks in between. And the judge gave like a huge departure because my argument was just that he was so institutionalized.
Yeah, it's like, and then once you become that institutionalized, it's a cycle, you can't get out of it. So I think you have to like go to your client and say, look, I know this sounds really weird, but do you want to be in here? Like if you do, that's okay. Like don't get mad at him for wanting to be in there, it's all he knows. Right, it's seriously like going to where your client is. It's really not, it's like if this was a person in your family, if this was like your nephew or your niece, and that's where they were at, and you wanted to try to help figure out how to help them, you would go to them and be like, look, man, what's going on with you? It seems like this is kind of your home. Is that what you want? Or do you want to try to change that? I'm here to help you with either one of those things. It's fine. And I think, and I don't know you, so I'm not judging you in any way, shape, or form by saying this, but you gotta check yourself, right? If what you're doing is you're approaching your client and you're fucking annoyed that you're like, you can't even comprehend how a human being on this planet would want to be in that situation, you gotta let go of that and just say, you know what? this person is this person, and whatever his shit is, and my job is to try to make this just a little bit easier for them.
So after you get through being verbally abused and possibly threatened because you're a lawyer.
Yeah,
then
it's fucking like the abuse, look, you think that abuse is at you?
Sometimes.
No.
It's not at you, you represent something, you represent the system, you are the place for his anger to be directed at, because you happen to be sitting there. Maybe nobody's actually bothered to have an actual conversation with this person. I have a client who is like, he is like that guy. He's been in jail like his whole fucking life. He's a homeless guy. He's a drug addict his whole life. The nicest fucking guy. I love this guy. I walked into, he was charged with going into like a, kind of like a city housing authorities locked off area and going in and stealing like a computer, and he was basically caught red-handed the computer. So I read the complaint and I'm like, I got nothing. I have no argument on the merits of the case. Like, the guy's fucked. Like, I read it, I'm like, this is never going anywhere. So I take the file and I put it down on the table and I'm like, so what's up? I didn't talk to him about his case at all, ever. Like, literally the only thing I ever said to him about his case was, you have to take a plea. So let's just figure out what kind of plea you want to take. But that was it, literally. The only thing I ever talked to him about was his life, why he was homeless, and how we were going to stop that. It's the only thing we ever talked about. And he and I had the best relationship. And I got him into a drug program, which I really didn't think he would ever make it through. But the plea offer they were offering him was kind of close to what he would get if he fucked up. So I was like, look, no harm, no foul. Give it a shot.
Yeah.
Take a shot. If you can't do it, you can't do it. Just like know that you tried. I want you to try. And he was like, okay. So he went to the program. He lasted like 2 weeks. And then he came back, and I went in the back, and I'm like, hey, what's up? I'm like, it didn't work, huh? You know what I mean? It was like totally fine. And he is like the sweetest man. And like, he writes to me, like, I love him. But like, he couldn't do it. But he tried. So it's just like, you just gotta go to where your client is. It's okay. I don't know, I have had one client, and I have had 20 years of clients, like as a public defender. Like, think about how many clients I've met in my life. I have one client who I looked into this kid's eyes, and there was nothing behind them. Nothing. Total sociopath, will spend the rest of his life in jail. No humanity, nothing. Literally nothing. One client like that. I have another client whose sentencing memo I brought with me to show you guys, who is a complete and total sociopath. But I kind of liked the guy. I didn't hate him.
I see a pattern here.
He would not, yeah, it's all about me. But he wasn't scary. He was scary, but in a different way. I'll tell you because I'm going to tell you about him anyway. When I met him, he had gotten arrested for attempted murder for trying to kill his girlfriend in an apartment, in her apartment, and the apartment, when I got the crime scene photos, looked like a bloody massacre. It looked like, seriously, like a horror movie. Like, you can't believe that this actually, and it's like from one person's body, blood like on the walls and crazy shit. He had 14 months earlier been released from having done a murder from the time he was 17, got convicted, and he did like 12 years, 13 years in prison. So he was like 40, got out, had a great job. You know, like our clients get out of prison, sometimes they can't fucking make it. He worked at New York Sports Club. He was a personal trainer. He was making money, and he met this woman. But think back, when he was 17, he went to prison.
He never had any real relationship.
He had no idea how to have a
Skills.
relationship with women. And he got himself like fucked up in this relationship where this woman was totally using him. And he got really mad and he fucking snapped and he just stabbed her. And I had to try the case because he was facing life no matter what I did. And the jury was out for like 2 weeks. And I lost. We beat the top count, which was really not all helpful, because he's still doing it. But and he was kind of scary guy also. But literally, those are the two clients in like thousands and thousands and thousands of clients that I have had, who I thought, wow, there's just not, you know, a whole lot of humanity here. But I can't say that for any other client. So you have to look, you gotta dig. You know, the things that our clients do not define them as people. There's something, you have to find that thing, just keep looking for it. There's something in every single client that you can find that you like. I swear.
Keep looking.
Okay, so I feel like, so let's think about like the idea of going to sentencing is like fighting a case. It's like going into war. It's like arm yourself, getting ready, doing everything you can to try to help and save this person, whatever it is, even if you shave like 2 years off the case or whatever you can get. So yeah, and then my little slide is about what we just talked about, like trying to find the humanity in our clients, like what actually makes them different than any other person you ever met in your life. And then it's sentencing, like, you know, my office is very much, we handle, I work the Bronx Defender, so we have civil lawyers and lawyers who do Article 10 proceedings in family court, which are abuse and neglect petitions. And we have, you know, all of that grew out of the criminal work that we do, and we have social workers and parent advocates, and so basically, and immigration lawyers, like anything and everything that you can imagine that grows out of a case and impacts on our clients' lives, we basically have some support network to either deal with that legal issue or non-legal, whatever that effect is. And so we've sort of developed a lot of expertise in sort of holistically how to help our clients. And so you want to think about the ramifications, the impact of what a conviction does to your client's life in every aspect. And those are the things that can really help build into mitigation in terms of punishment and sentencing. Because if you can say to a judge, look, my client's going to suffer in all of these ways, right? Sending our client to prison is like, whatever, to jail, or even to 30 days in jail. It's like a misdemeanor. Like, it's just utter overkill. Like, there is no purpose for it. They're going to suffer in all these other ways. But you've got to know what those other ways are. You have to understand how these other things are going to impact their life. Sorry, the slides are a little fucked up. Okay, so I think when you start to prepare, you know, I always like to go to my client first. And I know that sounds a little weird, but it's like, you know, it's a little bit like what you just said. You know, maybe your client actually wants to do 30 days in jail because he's like tired and he doesn't really have anywhere to go. And you know, that hasn't happened very often to me, but like a couple times my clients actually wanted to stay in jail for a little while. And, you know, that's like, it's a really hard concept for us because it's like, you know, we think constantly about prioritizing, like what's the most important thing to the client. Right? Is it their immigration consequences? Is it, you know, not being away from their family? Is it going to jail? Like, we always think going to jail is like the worst possible thing for our clients, but sometimes it's not actually like the most important priority for our clients. So I think it's worthwhile actually just talking about what all of those options are and alternatives are, and just finding out from your client what the issues are. I think for immigration consequence clients, I feel like that's always the priority. Which is really, really complicated, right? Because when that rubs up against jail time, and, you know, I have a client right now who smacked his wife over the head with a baseball bat in front of, like, you know, 20 people.
Domestic service.
It's like, not so good. And he's a non-citizen, and his 10-year-old son is going to testify because he was standing right there. It's like a disaster. And basically, like, I've gotten them down to offering him 2 consecutive years. So if you do 364 days, right? You guys like, so they'll do 2 consecutive 364s, which at least gives him a fighting chance at bail. Pending appeal, you know, it's, I mean, at an immigration court, like actually having an
Makes
argument.
him not an aggravated felon.
Correct, but he's probably going to lose anyway, but he at least has a shot, and he doesn't want it. And I think he's going to get completely fucked at trial. Like,
Come to do it as an Alfred plea.
they won't do that in my jurisdiction.
Oh, God.
How do they do it?
But
Oh, we would not get any business done if we couldn't do Alfred,
I'm
please.
telling
Yeah.
you.
Do you guys have that? Do you know what that is?
Yes.
Oh, okay.
Yeah, there's like one judge in the state that'll take
Yeah.
it.
Yeah, I used to do it in Brooklyn and Queens, you know, in other boroughs in New York, but, they don't do it in Brooklyn. I mean, in Bronx, at all. I've never been able to get an Alfred plea, 12 years.
I'd say maybe 75% of the time it's an Alfred
Oh,
plea.
yeah. You don't even have to ask anyone sometimes, you just say, Judge, that would be an Alfred plea.
Yeah, just
Prosecutor
because,
doesn't even look at you.
yeah. I didn't realize that wasn't a thing.
A lot of times I'll take an offer, and the prosecutor won't even know that I'm making an Alfred plea till I get up there.
Yeah, they only care when it's like there's
And that's
other
for
people.
immigration.
Yeah, co-defendant.
Well, immigration and just getting through the stupid canvas, because if you have to, if they, a lot of times, you know, all the judges are like, do you substantially agree with what the state's attorney said? Most of my clients are like,
Hell no.
hell no. So Alfred, it's like, okay, we can get it through, you know?
And if they disagree with just one little part of it, like the
It-
time or the color of the car or something,
See, taking a
That's
plea
it.
is in where I am, it's like it's absolutely, you have to allocate to the facts, you have to allocate to the facts that they want.
They swear them in.
Swear them in.
Oh, shoot.
Wow, that's really interesting.
Oh, yeah.
Okay, so they're sort of considering like what your client wants and what, you know, where their priorities are. And I kind of like to think about it literally that way, like a list of priorities that, and sort of identifying what they are. You know, and then obviously you have to know your sentencing rules, especially for you federal people. You must know these things because it's your whole life, right? But like, I mean everything. So like, you know, fines, post-release, you know, orders, alternatives to incarceration, options that exist in prison that are either in the court's discretion or not in the court's discretion, so that you can try to like get things for your client. SORA, civil commitment, which I assume you guys do have that stuff. You're looking really low. Do you have like, okay, so sex offender registration,
Yes,
SORA.
like that.
Civil commitment is the craziest shit ever. So all those things are like really important to understand. And then the collateral consequences, which I was talking about, immigration, housing, employment, public benefits. Like, I don't even know if you guys know all those things, but so there's, I didn't really know that I was gonna be doing this time, but the last time I did this. So there's some, if you don't have like good resources in your office about these things, like there's some really good websites, and we have on our website like links on reentry.net on our website to like all of these really great resources that talk about like state by state what the consequences are. Like there's this thing, like the Legal Action Center in New York did this thing called Roadblocks to Reentry, and so it's like all of these, you know, it's literally like about everything, about adoption, foster parenting, like how penalties and convictions affect your life, the consequences afterwards, and
What's
all
the
that.
website that you have, your, like,
My office is just, it's the Bronx Defenders, and you can go on the website, and we have something called reentry.net, and it has like links to all of this information. And this one is on the Legal Action Center website, which is lac.org, and they have a whole reentry thing. And then this is kind of like, you know, the reentry.net materials from our website, and it sort of goes through like every possible collateral consequence and state by state how it affects you. So that can be like a really interesting way to also, you know, sort of frame things in your sentencing. So it just gives you a lot of other tools to kind of work through. And then, you know, the last piece is just like, maybe you need a shrink, like to go talk to your client. Like, can you handle the scope of what you're writing a sentencing memo about, or do you need somebody to actually help you through that process and do it? I mean, I don't know about funding and whether you have access to those things, but, you know, on the sentencing on the guy that I just told you about, the guy that did life, did 17 years on a murder and then got reconvicted, like, I didn't really know what the fuck to do with this man. Like, I didn't know, you know, he was a guy, like, what do you say? Right, like really, what do you say? And so I got a forensic psychiatrist to go talk to him because I was really struggling he has a little bit of that kind of demeanor where things it doesn't seem to trouble him. And it's sort of like, he almost seems like a trauma victim who's like sort of flat. Like he can't really figure out what's going on with him. And I represented him for like 2 years. And he's always sort of like, hey Carol, with a big smile on his face. Like, I could never figure any of it out. He also lied to me, shockingly, completely and totally about, they had, he wanted me to serve alibi notice for him. We talked it through a lot, and we were gonna call his nephew. It wasn't really an alibi, it was like a circumstantial alibi. Like he had been in this place and then he was in this place, and we were gonna try to argue that he couldn't be at the other location. So the prosecutor's office subpoenaed what's called, the like satellite pings from his phone. Has anybody ever had that happen? So I say to him, look, they're gonna subpoena your phone records and they're gonna get the sites and, to see the location where you were. He's like, that's good. I'm like, Jose, they're gonna find out exactly where you were. Did you make phone calls? If you made phone calls, we can withdraw the alibi. Like looking him like right in the face, it's fine. Like, oh, that's cool. Like, you sure? That's good. Put him literally right in the building. Like there's like a cell tower on the top of the woman, like the building across the street from where she got there. So the cell tower showed that he was right there. But I have to tell you something. Of course, I practice in the Bronx, and Bronx girls believe anything. But with the cell tower thing, really all they can tell you is that it's in a
Within a
6-mile radius or something.
Yeah.
So we did these maps with 6 miles around the location. And like 6 miles in the city, in New York City, it's like far, do you know what I mean? So it's like 6 miles in that direction was like, at the Throgs Neck Bridge. So we crossed the woman from Verizon or wherever she was from, and the jury did not believe that testimony at all, which I could not believe, because when I got the results back, I'm like, you have to take a plea. You're so fucked, this is not even funny. But he literally, it's like, I kind of looked at him like, I don't understand. Like, he's like one of those guys, like, he just thinks if he says it, it'll make it true. It's just whacked. So, anyway, but I needed help with him, so I hired somebody. So it's like, just give yourself a chance to do that. Okay, so the next thing is just sort of like imagining what the prosecutor is gonna ask for, right? Like, and really doing it. Like, so, my example here is like that I tried this case that I told you that I still like relive every minute. And so it was a sex case. It was a forcible anal sodomy in a staircase. And they convicted him not of the top count, but of, I think, sexual, I don't remember, some lesser than the top count. Which was great because, we beat the top count. It wasn't great, but whatever. It seemed like it wasn't so bad. But then apparently the case law is really, really bad on consecutive time on sex cases. So if you touch somebody's breast and then you touch their ass, that's consecutive time, even though it's like one incident. Because you don't understand even in the law, I just don't get it. But anyway, so the case law was horrible on the issue. And I was worried that she was going to ask for consecutive time, but we never talked about it, like, before. The word sort of had never come out of the prosecutor's mouth. So I go into sentencing, and she asked for consecutive time, and then I had a memo prepared on why, a separate memo. Like, I didn't want to bring it up in the sentencing document that I submitted, because I didn't want to raise it if she hadn't thought of it. I just didn't know if she was going to go there. So she did, so I separately had prepared a memo on why consecutive time is inappropriate in the circumstances. So that's a way to sort of think through the worst possible scenario, what are the worst consequences you can imagine for your client, and then trying to figure out strategically how to actually deal with, how to approach that. And for me, that was the way to do it, because sometimes you don't want to tip your hand. So, think a little bit creatively about how to do that too.
How did the judge handle getting that memo? I mean, did he still go before she go forward with sentencing that day?
She actually took a break,
Okay.
and she went, and she told us to come back after a while, until she researched it, and I think she understood why I didn't, you know, she was actually, I mean, she was horrible and could sack my guy in sentencing, and the case law sucks, and it's fine. But, you know, it was also really helpful to think all of that through for my client. Because like at the time when he was convicted, it never crossed my mind that he was gonna get consecutive time. So he was like, well, this really sucks, but at least I can't get more than whatever it was. 7, I think it was 7 was the max or whatever. But it was really 14. So preparing him for the sentencing was really important, right? Like sitting down with him and being like, I know this really sucks. You know, because he had thought that he beat the offer, because the offer was like 10 or something. And so that was really difficult. But yeah, I think if you have like, but I think, you know what, even if you have a judge that's like annoyed at you, it's like, okay, fine, we'll adjourn it. But that way you at least sort of manage to not, you know, at least you feel better like you didn't give them the idea. You know, the consecutive bias. So you also obviously want to get a sense of what the judge is, what's going on with the judge, right? Like, who is this judge? What are the hot button issues for this judge? You know, is the judge just a shit judge about everything? Are there certain things that annoy your judge? And are there certain kind of cases that bother your judge? And if you don't know, like, find out, ask people. There's like tons of people, right, that have tried cases in front of these. Just make sure you know what the deal is with the judge on sentencing. And then you sort of like want to both plan about thinking through what both of them are saying. It's a little bit like Y-storming, right? Like, what is the biggest concern the judge is going to have? What's the argument the prosecutor is going to actually bring up? And how do I actually have a plan to deal with both of those? How do I answer both of those problems? And begin to sort of talk through what the collateral consequences are in your own mind for this person and what the alternatives that exist. And you want to really like put all of that together as part of your plan. Yeah.
What do you do, like, where should the, like, victims, like, if you know the victim's gonna come in and, like, do a huge thing, you just kind of go in that step, like, okay, what do we add, like, do we kind of address two, like, I just know, like,
Yeah, I
I'm
think
coming up next, like, you're gonna come back, and I'm like, the victims are gonna come in and be like,
So what are yes, I think you absolutely have to think about that.
okay, so just
What
kind
are
of,
the issues with that?
I have, like, an attempted home evasion with guns, and my client has, like, no real record. He has, like, a New York record. He came from New York to, like, I mean, there's multiple different stories, but, like, he came to, like, see a girl or whatever, ended up with this other guy. My client didn't even know where Hereford was, you know, I mean, and ended up in this car with this guy, and zip ties, and guns in the car, not good. So I have, like, a cap.
Zip tie time, like.
Was he there for the home invasion too, or?
Well, there was an actual, they like
was like a
went to
plan?
there was like a plan, they like went to the thing, supposedly one or both of them, it depends on which victim you talk to, went to the door, and it turns out actually there was a big drug house right next door, like they actually went to the drug
That's where they were
house.
going.
Yeah, they really should have, you know, but, so I know the victims are gonna come in and be all, you know, I don't even know what to say, like this guy was at my door, and
Was this a plea?
it was a plea,
Yeah.
I have a cap, you know, right.
So you
Sorry,
did
down.
you ever get like a statement from the victims as an part of your investigation on the case?
Well, no.
Are you
They,
guys allowed to do that, or do you have
we
investigators?
can if
that
they'll
go
talk to us,
and
they
say
won't talk to us.
that?
Yeah, a lot of
This
times their
person would-
attorneys
Yeah.
will say, don't talk to their investigator, and we're stuck with
You
that.
mean the prosecutor, or?
The state's attorney, I will
Yeah.
Sometimes they have a state attorney, and sometimes the victim's lawyer up too, like they get private counsel, depending on what's going on.
sometimes, this one they
Because
did
they're
not.
filing a civil lawsuit sometimes, and
Yeah.
things
That
like
makes
that.
sense.
Yeah, no, so it's like, I can
Yeah.
argue down to 4,
Right.
from like 6 is the max.
So they
but
never actually got into the house?
They never actually got to the house, but
So
home
what the fuck
invasions.
are the victims all pissed off
Well,
about?
I have no idea, that's what I'm saying, but I don't know how to address, like, how do
Okay.
I, like,
Right.
you know, obviously it's scary, especially when you find out these guys have the guns and zip ties, but like, if you never knew that, you would be
Exactly.
upset, yeah.
Okay, so I think, I think that, like, I think so, what the issue is like, there's a lot of, what ifs. It's sort of like the most annoying thing about sentencing, right? When they're like, if he had burned the house down, people could have died. It's like, well, but they didn't.
Yeah.
I think you need to just address that, which is, but you think you can't ever take anything away from a victim on sentencing, right?
that's
Like,
the
so
thing,
you have to sort of acknowledge, like, there are things that are really scary about the circumstance, but the reality is we need to look at the true impact that this had, and thankfully, nothing happened, and, these people were very lucky, and, whatever fear that they suffered, we're not gonna try to minimize that, but in terms of true harm, and, just, I think that's kind of the way I would approach it. But I would definitely deal with it, don't pretend it's not there,
It's
right?
not there,
You can't pretend
obviously,
it's
but
not
it's
there.
like, you have to kind of think that.
And one of the memos that I have, which if we ever get to it, I'll show it to you, but it's like, it was really hard because first of all, she testified, and my client completely like fucked up her face, she had surgery, it was
the judge saw
a nightmare, yeah. Yeah, no, and I had her on the stand for like 2 days. She fucking hated my guts, hated me. The one piece of shit. She did lie, she just didn't lie about the fact that my client cut her out, but she lied about many other things, so. Okay, so this is about really your question, right? Like, how do you tell your client's story? How do you humanize your clients? How do you figure out what the story is? And, how do you craft a way to communicate, like, what's unique and special about them? The first thing is like trying to also just think about how the message that you're sending is being, heard, right? So there are things that I think that judges can hear, and then there are things where they just like don't give a shit about. So you have to like really, there are things that we find sympathetic and empathetic about our clients, but sometimes the court is not going to see it quite that way. And so particularly, on sentencing, I think it's really important to like find those things, the things that you think that the court's going to relate to, because I think, sometimes we can find these like, empathetic things, and they're not really particularly helpful in that context. So you want to figure out the story, right? So there's a story, there's like a lot of stories in there. There's a client's life story, there's the trial story, there's maybe the trial story that you wanted to tell at trial, but you couldn't tell because, you didn't think the jury would buy it, or you couldn't tell because your client couldn't get on the stand, or it was sort of it wasn't truly a defense, right? Like that's the case with the guy that cut up his girlfriend. Like I sort of told a real story in there, which we can talk about. And then I think, you have to like see what the judge sees in your client. Like try to really honestly look at your client the way that the prosecutors and the court is going to look at them. So for like my client, Jose, like how do you not look at that guy and say, oh my God, you killed somebody, you almost killed somebody else, like what do you say about that? Like that's literally what the court sees, and it's true, like you have to deal with that, and you still have to figure out a way to write something that is reasonable, strong, powerful, even if you don't win, right, you still need to be able to stand there and fight for your client, even at that phase. And see if you can figure out how to, undo that belief, right? So that's why with him, like I wanted to get a shrink, because I really wanted to see if there was something in there that I was missing that I could try to tell as a story about him or his life. That was the other problem with him, is like he came from like a decent family. It wasn't like I could be like, oh, well, he was abused as a kid, or like there wasn't the story.
That plays against us,
It does, but at least on sentencing, it's like you can explain, like on some level, like where this came from and whether there's hope for change, right? Like that's, you always have to have like that storyline, right? And so, which is kind of a little bit like what happened for him, right? There has to be, you have to be able, it's like, we talked a little bit in like, when we were doing openings about like that pivotal moment where like it's like that hook moment where people had to make decisions. It's a decision point, it's a tipping point. So you have to create a tipping point, right? Like for your clients, like this thing happened, this event took place, but the process of having been incarcerated, waiting to go to trial, ultimately taking a plea, going to trial, sitting through the trial, and now being here at sentencing, talking to a therapist, talking to a shrink, has now gotten them to the place where they acknowledge and for the first time in their life can begin to see the patterns of their life and maybe now start to change going forward. Like that may be the very best thing that you have to say. And you have to say it with support, with some level of credibility. Because if that's, that's literally for him, that was the only thing that I could say. Like, this is a person who really had a whole host of complicated issues, psychological issues as he was growing up, but like really had never dealt with it, never really thought about women, about relationships with women, about his relationship with his mother. But a lot of our clients, like, they don't have access to resources to actually like figure some of that shit out, and so they go through their whole lives like not even getting that that's what's going on with them. So
I have a question
yeah.
about, so your sentencing story after trial,
yeah,
obviously your trial story, if you're in sentencing, didn't go so well.
Yeah.
And the jury didn't believe it.
Right.
Usually the judge didn't believe it either.
Yeah.
So sort of,
it's the hardest thing. Well, it's the hardest thing when you also want to take the case up on appeal, right?
Yeah.
So you're at this like weird crossroads, right? So you're like, I don't want to admit guilt because, my client has real appellate issues. So I have these two memos that I'm going to read to you,
okay.
in the next 4 minutes. Which, and if you guys want to look at any, I can email them to you. Just give me your email addresses and I can, just because I have a whole bunch of like samples of how to do this kind of in a really like a creative, thematic way. But both of these are really good examples. One of them, I never admitted guilt. I just didn't go there because I think he still, his case hasn't gone up on appeal, but he has like all of these really interesting appellate issues in his case. The other guy, Jose, I'm like, he has no fucking issues. He doesn't have, I just didn't think he had any appellate issues, and because of the weight of the evidence and the kind of case it was, and I just think there was no way that even if there was an appellate issue, that the court would do anything about it. So I ultimately decided that there was no, and I talked to him about it. And, obviously you have to do that. But like for him, I was like, there's no point in you going in here and standing your ground and saying you didn't do it. Like, maybe it will help you. Although for him, again, like weighing it, he was on lifetime parole. Like, he's never going to get out of jail no matter what he does. So I don't know, maybe it's better to just say, fuck it, like, shot in the dark on his appeal, shut up, don't say anything. Like, you really have to weigh that. But, so then there is no story of the trial, right? Or you have to skate it, which is what I did in this report, so we can show it to you. But so it's like sort of getting close enough to the line, and then being able to anticipate that the prosecutor is going to say, well, he hasn't admitted his guilt, he hasn't come forward. It's like, being able to say, well, look, my client has appellate rights, and, that's not at issue here, like the jury found what they found, and this isn't about my client's remorse or lack of remorse. He has rights, and that's not even, but you have to know that they're going to go there. Because that's kind of like what happens. It's like, the client, and the judge punished my client, that consecutive case, for not, for sort of blaming the victim, and because our defense was consent. And so she did blame him for that, for not coming forward and being able to, but in the end, like, we just felt like we couldn't go there. So that's like a choice a very conscious choice that you have to make, and really weigh it and talk to your client about it. So I write something all the time. You should be submitting something in writing, try to do it ahead of time. And, so it's like using, did I not change the slide? Okay. So, like all of those narrative techniques that, I'm not even sure that really Jeff sort of very clearly like set them out, but it's like when he did his thing, but it's like, thematic presentation, narrative techniques like developing a character, think about the arc of the story that you're telling, right? Like, what's your primacy, recency, where are the pieces, the scenes you want to create, right? It's just like doing an opening, like what is the first scene, what's the second scene, and take these moments of the person's life and figure out how to like tell that story. You can submit a letter from your client. I just did that on a sentencing. I let my client write it in his own handwriting. I told the judge that I didn't tell him what to write. I told him that these were his words verbatim. I didn't change anything. I didn't direct it. I want you to see how my client really feels. You know, you can use what happens at the trial because the judge knows those things and sort of try to make the most of those mitigating facts. If you have the ability to talk to your jurors in your jurisdiction, you can try to use that as a mechanism to get through to some of the issues that the jurors saw, the things that troubled them about the case. You know, you can attach attachments, medical records, letters from people, transcripts, you know, shit your client does in prison, in jail while they're waiting, if they've been involved in programs. Is something else coming in here at 11 o'clock? No.
Yeah, just go 1:15 minutes.
Oh, we have to go downstairs, okay.
Yeah.
Collateral consequences and all that stuff should also go into your written piece. And then, you know, your oral piece of this needs to be just as interesting, right? So it's like, think about that. Like, you don't just go in there and be like, because I've done this. Like, I write a whole really wonderful thing, and I don't even think about sort of the oral aspect of it, because I figure, oh, well, the judge is just going to read the thing. Why the fuck do I need to even think about what I'm going to say? But the truth is you have to stand up there and say something at sentencing, right? And so the question is, do you want to sort of say the same thing? Do you want to present this differently? Practice it. Do it just like you're going to do an opening. You know, talk to your client and prepare him for his statement. How many times does that fucking happen when you go in there and they're like, you know, what are you gonna do with your client? Do you want him to say something? Do you not want him to say something? What do you want him to say? It's just like practicing direct. Like, go over it with your client. Make sure that you like really have something. Do you want him to make an admission of his guilt? Do you not? Is this a moment where you don't really want your client to speak? Do you want to speak for him? Like, you can do any and all of those things. It's nice to have somebody come to court for your client at the time of sentencing. Even if you can't get them to come through the whole trial, and your client's sitting there alone in the courtroom the whole time. Find the right balance, like the emotional pitch. Like, I think sometimes if we go too over the top at sentencing, the judge like gets mad at us and sort of punishes us or punishes our client for like our over advocacy in that moment. And I feel like that's an issue in my office, like, you know, because we like really care about our clients and that's sort of the, you know, office culture. Like, sometimes we get a lot of shit for being like too client-centered, and so it's like you have to really create a good balance so that you always have credibility with the court, because that's obviously at this point it's all in their hands, and you gotta make sure that you find that space. You know, going back to the purpose of sentencing and the goals of sentencing, like if you can find something about it, like if this is, you know, rehabilitation, you know, including some measure of punishment, and, you know, to sort of balance at least in the equities, like what the actual goals of sentencing are. It can be helpful to the judge to sort of remind them really what those things are. And then, like, as you do your oral presentation, like, don't forget all the things that you learned here about performance, right? Like, use your voice, use your hands. Like, it's not any different than any other performance moment. It's really important, you know? So it's like, just equate it to your opening or your closing or a moment of really, you know, important moment, and just don't blow it off because of all the things that we talked about before you got here about, like, how horrible it is to go to sentencing and why we hate it and why we want to avoid it and all that. So, and then this slide is just about structure, right? Which, I'm, you know, been pushing this all week if I had you and improved, but if I didn't, like, structure is so important, right? So you really want to think about, you know, the sort of, the typical structure, which I hate. It's like the bail application, right? Like, think about your structure. Like, the beginning paragraph of almost every sentencing memo that got submitted in my office for the first, like, 4 years reads like this. Please accept this sentencing letter on behalf of blah, 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 who pled guilty to blah, blah, blah. He acknowledges his guilt in this matter and is remorseful for his actions. Like, this is the most boring fucking shit you've ever heard of. And I can tell you, like, over and over, they all start the same way.
I'm writing this letter on behalf of my client, who is acquitted by your honor of these counts and convicted of these. He's, blah, blah, based on his lack of criminal history, I mean, can't believe that somebody in my office even wrote this crap. Like, to me, this is just the most boring thing ever in the world. So, don't do that, right? Like, step back and say, this has to be interesting and persuasive, and the structure is what guides it. Okay, so there is no such thing as a standard form. There is no such thing as, oh, this is the way a sentencing letter has to look. It's not, I mean, I don't know, maybe in federal court it's different where the judges, no. Okay, and so, like, what you want to do, and what I try to do when I read and help edit people's written materials on this, which you now know is called smolarizing. Yes, it has a name to it. But when I do that, it's like I'm looking for what pops to me. Like, what is the thing that really jumps out as being different about this client or this case, or the thing that pulls you in. And that's the thing that needs to lead and sort of push through the narrative. And the narrative structure has to grow out of what you have. And so do all these things. It's the same things that we do when we try to structure an interesting and creative opening or a closing. The beginning has to be strong and the end has to be strong. So, I'm trying to think if any of you guys are in the room. So I had this case, I don't think I told any of you guys about this, where my client murdered his boss and then disarticulated his body.
Oh, I was there.
Which means to cut him up at all of his joints, and then took all the little pieces of his body, put them in plastic bags, and went on a bicycle and strewn them all over the Bronx and various places. And so he was convicted after trial, and shockingly. So I had done a full-on first-person opening statement in this case, in his voice. And so this is the way the sentencing letter starts. It's with a quote, and it's in quotes. And it's cited to his statement during the interrogation. The guy like a monster man, nobody like a guy that whip you and whip you and whip you all day, every day, every day, every day, and don't let you alone, And that's like before, that's like the first thing. And then this is how it starts. On the night of May 9th, 2006, after enduring repeated physical assaults, threats to his life, and the staggering amount of harassment for over a year, Mr. Victor Gonzalez finally snapped. He said it best in his own words, "I lost my mind." Earlier that evening in his own apartment, he had been confronted, threatened, and brutally attacked by his boss and tormentor, Mr. Wilfredo Freddie Pinto LeBron Jr. Later, when Mr. LeBron attacked him a second time, as Mr. Gonzalez walked to the bathroom to take a shower, Mr. Gonzalez believed that Mr. LeBron was about to get a weapon and felt that he had no choice but to defend himself. He took a hammer that he had brought with him in case Mr. LeBron confronted him again and used it to strike Mr. LeBron in the head. Once he began to strike him, the floodgates of the past year and a half of abuse took over. He was no longer able to control himself and entered into a dissociative state brought on by the intense emotional trauma of the situation. Mr. LeBron lost his life by the repeated blows to the head with a hammer by Mr. Gonzalez. So it's like that's how I started the sentencing, just to sort of paint the picture of what happened to him that night. And just like structurally, just for you guys to look at this, we have this section that talks about like all of the abuse that my client had suffered at his hands. And it's literally like these bullet points for like 3 pages, which is, we did it like this on purpose because it's like, just so the judge can see it. So it's like laid out,
Really
like,
set out, yeah.
like this. Like, so for us, like structurally, we sort of wanted to tell the story of his life, of that night. And then, and we had a psychiatric report done of him, so we had a lot of stuff. And then just to deal with sort of the victim part and the crime part, so that's like the first paragraph. The second paragraph is, there is no doubt that this is a horrific crime. However, his violent response to Mr. LeBron's treatment is totally aberrational. And then we sort of went back and talked about his life and attached attachments.
So if you wanna take a look, this is like one of the worst cases I've ever tried. I mean, literally the worst case factually that I've ever worked on. And this is a 8-page sentencing memo, single space, like really thorough with history, psychiatric stuff to support it, everything. So this is like an example of
Can I
that.
ask a question?
Yeah.
Is this on top, in Connecticut, we do what's called the pre-sentence investigation too? Is this on top, like, cause if a lot of it is gonna be
Do you
encompassed
do
in that?
it, or does some agency do it?
Probation does it,
Yeah.
but we get to be there. And actually, it depends on your writer. One of them I will never trust anything she says because she just twists everything. But there are two that are really, really good. So like I don't want to like rehash necessarily. I use something. If whatever I do, I like add to what I think they've gotten. But I don't know like what
And you get it ahead of time so you know what it's gonna be?
I have 2 days at least ahead of time.
I mean,
It's
not to
fine.
make more work for you, but first of all, we have pre-sentencing reports, they don't actually say anything.
Oh, okay.
And half the time they say shit that's just outright just completely wrong. So I don't even consider that as being anything
And
useful.
part of it.
Like, I
Okay.
don't even consider it, like,
The
it's like,
only time it's useful to me is if I have a joint recommendation in the plea agreement and
Oh,
like,
okay.
there's the off chance
Yeah.
probation will give something less than that, and I'm not allowed to say something.
But you know why the PSI report is so important to us?
That's what
The
judge goes
judges
off of.
live by whatever is in it.
Yeah, that's what they go by.
That's what they go by, like, they will take that, they probably won't even read our memo, but they will read the PSI.
okay, well, just, I think I had this in there somewhere, but I didn't say it, but like, you need to write this thing and get it done before the sentencing date and make sure you hand it into the judge so they have time to read it.
Mhm.
And actually, what I'll do, if I think the judge, I don't have, the judges in where I work are actually pretty cool, and they would never do a sentencing and not read it. But I actually will go up to the judge and be like, so, you know, you read my sentencing memo, right? Like, what did you think about this thing? Like, I'll actually sort of make sure that they read it.
Yeah.
And then I'll say, you know, Judge, if you didn't have a chance to look at it, I'm happy to adjourn the sentencing so you can read it. Do whatever you can to like, you know,
Okay.
sort of make sure. I would not rely on any agency. Like, my whole point is you want to put this out there
In
the
your
way
own
you want
words,
to.
yeah.
And you want to do it in the most persuasive way that you can. And that ain't it, you know what I mean?
Oh,
No
I
matter
agree.
what you do, it isn't. And if you get it and it helps you in some fashion, you can cite to it, or like,
That's
I would
what
have a draft done before you get that thing.
Okay.
So I'm just gonna like, this is this case where, I'd like to show you the other one with Jose, but I don't think I'm gonna talk for you to do that. But this is the case where my client got convicted with the thing in the staircase. It was a horrific fucking crime because the complainant was like the most vulnerable victim person ever. So this is just the way this started. And again, this is like, the thing was like the incident itself, right? Like that was the biggest issue. So this is how I started it. It's like going to what the issues are, right? It's nearly impossible to sum up a man's life in a few pages of text. It is even less realistic to attempt to understand him by looking at one event, a few moments of time in his complex life. But on June, 2010, a Bronx jury convicted him of 2 counts of sex abuse in the 2nd degree, and this court must determine the appropriate incarceratory sentence for this act and this man. Herbert Williams is a complex man with a rich family and personal history. It is that man that found himself on that street at that time, whatever, I don't know the details. But his encounter with her is not emblematic of who he is as a person. Instead, it is illustrative of terrible decision-making, awful judgment, and an inability to perceive the frailties of another person. Unlike the way in which he was characterized by the prosecution, Mr. Williams is a gentle man. He feels deeply sorry that he did not see Stephanie George, the complainant, for who she really is, a mentally ill, intellectually limited young woman. Had he understood those things, he never would have even approached her on that street. So this is just like, that's like going to where the judge is, right? Like, you know that's what's bugging her, right? And trying to find a way to change that space where the judge is at. And it's really forcing yourself to look at like all the shit that's there and then confronting it and just taking it on. And sort of the structure of this was like his background, like his history, like the bad choices that he made, the choice that he led him, and all of, and I think the way we did this, which I like to do, is sort of create these little headings for the court so that reading it is a lot easier. So you can create headlines to create the structure, so the structure sort of flows. And again, it doesn't have to be chronology, right? You can structure the thing any way you want in these scenes that sort of tell the arc of the story that you want to tell. So make sure that the structure feeds the story that you want to tell. So anyway, sorry it took so long to not really get to everything I wanted to talk about, but we talked about bail applications, so that was good. So anyway, I can send you guys just some samples if you want to see them, just to get a sense of how to do this.
That'd be great.
more creatively.
Thank you.
Thank you so much.
I have a question.
Oh, no, you go first.
Yeah. Yeah, because I didn't put them on the stand, but I'll talk to you about.
Okay,
Yeah, thank you.
What do you do when your client like really is sort of adamant that you ask for something that you know is so low that strategically it's not a good idea? I mean, like even, you know, I just have a lot of clients who, you know, think the legal reentry guidelines are totally crazy, which they totally are.
Right.
But like I have a good sense of the judges and where you might be able to ask for a little bit less and get some traction.
Right, but
Too
being,
much
it's
is just
seems
ridiculous.
unreasonable. I guess what I would do is try to, you know,
I mean, I
obviously
try
not
to, but
really
it's-
try to explain it. I think then, well, how about couching the request for it? I don't know how your judges would deal with this, but in terms of what your client wants, right? Mr. Williams has, you know, asked me to ask this court to consider this, as opposed to saying, do this.
This is
Because
the
then
most
it's-
reasonable
right,
sentence.
Exactly, because you're sort of conveying, like, I understand that's not gonna happen, but you're still advocating for your client because they want you to, and that'll make them feel better.
Yeah, I have this client who's like, how are you gonna ask? Like, what are you doing? And I'm like, I can ask that.
I'm not, do you have to ask for a number? Like, do you do?
have to. The government like submits a sentencing summary chart, probation submits
I
a
see.
report that has a number, and like typically that's my headline.
Right.
It's like, this is the most appropriate sentence. Because that's what the
Right.
judge really wants to know what I'm asking.
That's interesting. So I think what you have to do there is say to your client, like, look, I can do this one of two ways. I can ask for, this. I'm telling you right now, I don't think it's gonna be successful. I don't think it's gonna help you. But I actually have to put a number down. This is the number that I think is gonna work. You know, like, you tell me, you know, I think ultimately I would leave it up to your client. Like, it is, and my sense is that you probably have a pretty good relationship with your client, so.
Yes,
You know,
except
I-
this
I-
guy is just like totally insane.
Yeah, I'm
because he
sure
has-
it doesn't happen that often, right? That's my guess.
No, I mean, usually I can convince the client that the number I think is the like appropriate number to ask is the good, you know, like I haven't had clients sort of like force me to
Do stupid things,
pre-commit
yeah.
to like a particular number. I mean, and he would wish I asked for 6 months. I mean, and to be fair, he also, pineapple, like we had an executed plea agreement, he showed up in court, the judge was like, do you understand what's going on today? He's like, no, I don't want to plead guilty. I was like, oh god.
Oh, so you
Then
have like a
we were-
total implosion.
And then we were lucky because the prosecutor who we got post-indictment was pregnant, and so she was like, I've been given discretion to give you that deal back.
That's good.
Thank God.
Thank you for